When we talk about custody in North Carolina, we're really talking about two types of custody: legal custody and physical custody. Legal custody refers to the authority for parents to make decisions for minor children. And those decisions are medical decisions, educational decisions, decisions about religious upbringing, and other major decisions. Physical custody refers to where the children actually live, and joint physical custody arrangements are common. Joint custody doesn't necessarily mean equal custody. It just means that the children live with each parent part of the time. But it is very common for parents to share custody relatively equally. In North Carolina, judges make decisions for child custody based on the best interests of the child. Best interests of the child means the judges take into account lots of different factors. They may decide custody based on how the parents treat each other and what impact that has on the children. It may be based on views that the parent has that is negatively affecting the child. For example, sometimes parents have disagreements over whether the child should be medicated or whether the child should receive vaccines. And so, based on all the circumstances of every unique family, the judge has to decide what's best for your child in a custody battle. In North Carolina, if you're not happy with a child custody order and you want it changed, you have to show the court that, number one, there's been a substantial change in circumstances since the last court order was entered. Number two, that substantial change in circumstances has in some way affected the best interests of your child. Some substantial changes in circumstances that I've seen over the years have been one parent has gotten involved in substance abuse, or they've had a DWI while the child was in the car, or maybe they just moved several school districts away and it's no longer practical for the parents to share custody equally. Another example of a substantial change in circumstances I've seen is one parent's gotten involved in a new relationship and there's domestic violence in that relationship and the child's being exposed to that, and that is certainly something that would affect the best interest of your child. In North Carolina, you can move with your child after a court order has been entered, but you're going to have to file a motion to modify and ask the court permission. You can't just move out of state with your child with a court order that says that you're supposed to be sharing custody equally with the other child. That's a recipe for making a judge very angry and probably losing custody. If you have any questions about child custody in North Carolina, we'd be glad to help you. Give us a call here at Advocate Family Law Group.